Continuing now with The Final Days by Bob Woodward and Carl Bernstein. In this session, we now move on to Chapter 9. Peter Wallace Rodino, Jr. of Grafton Avenue, Newark, New Jersey, age 64. In World War II, one of the first enlisted men to be commissioned while overseas. A man proud of his awards. In the 1971 Congressional Directory, he included the Cavalier di Gran Croce of the Order of Al Merito della Repubblica and the Bloomfield College Upward Bound Certificate of Appreciation for outstanding service, personal interest, and concern. After the Saturday Night Massacre, 22 resolutions of impeachment had been introduced in the House of Representatives, and Speaker Carl Albert decided they would go to the Judiciary Committee, which was headed by Rodino. The committee had handled the confirmation hearings of Vice President Ford and done a thorough, fair job, Albert thought. Rodino searched for the right person to head the staff of the committee's impeachment investigation. All the men who were interviewed for the job were asked how they would conduct an inquiry. By Christmas, Rodino had found the perfect candidate, John Doerr, 52, a Wisconsin Republican, former head of the Justice Department's Civil Rights Division under Presidents Kennedy and Johnson. Doerr's answers corresponded with Rodino's thoughts on an impeachment inquiry. Keep it nonpartisan, objective, thorough. Saturate the members with the evidence. Doerr, skeptical, stone-faced, nearly humorless in demeanor, was not the type to repeat the mistakes of the Senate Watergate Committee. The White House had likened that inquiry to a witch hunt. Secret testimony had been routinely leaked, and witnesses had been compelled to testify under grants of limited immunity from prosecution. Rodino and Doerr were determined to reestablish public confidence to the integrity of congressional investigation. Doerr set up shop in seedy quarters in the old Congressional Hotel, where the staff's work was carried out in small rooms with the blinds pulled as security guards patrolled the halls. Doerr's solution to the possibility of leaks was to compartmentalize the inquiry and therefore the developing information. Only he and a few others had full access to material. Doerr announced 3 absolute rules to his staff of 101. Be punctual to all meetings. Learn to understand and respect the filing system. Make sure your desk is clean every night. When he learned that a member of the staff, William Dixon, had taken some campaign financing files from the office, some were in his car, others at home, and still more in his briefcase, Doerr dressed him down. What would happen if Dixon were killed on the way home from work, he asked. Dixon tried a joke. I have some life insurance. Doerr interrupted. The greatest tribute to a man would be that if he died, someone could come into his office the next day and pick up where he left off. Even with James St. Clair on the scene, Haig thought he ought to maintain the personal relationship he had so carefully nurtured with Jaworski. He informed St. Clair to focus totally on the impeachment inquiry. At all costs, Haig wanted to avoid a court battle with Jaworski over additional tapes, the very question of future access which had figured in Cox's firing. Stepping away from confrontation in December, Haig had persuaded the president to let Jaworski come to the White House and listen to some tapes which were not under subpoena and to look at some files. Though the flow of information was a trickle, it was useful to Jaworski. He too wished to avoid a protracted court struggle. But in late December, the president ordered Haig to reject any further requests. Jaworski contacted Haig in early January. He had another request. He wanted to hear one more tape. If he could listen, he told Haig, he might be able to judge which additional tapes, if any, were essential to his investigation. Deliberately, he let Haig form the impression that the request for more evidence would soon cease if this single tape were made available. Jaworski's plan was to proceed one step at a time. He wanted to hear the tape of June 4th, 1973, the so-called tape of tapes, a recording of presidential conversations on the day when Nixon had spent almost 12 hours listening to his conversations with Dean. Haig went to ask the president, indicating that this would probably be the last request from Jaworski. Nixon asked Bizart to listen to the tape. Bizart strongly recommended that Jaworski not be allowed to hear it. The tape clearly showed the president, Haig, and Ziegler plotting to ambush Dean, and as well the president acknowledging that he might be involved in the cover-up. Bizart told Haig that the tape would provide Jaworski with a list of other conversations the president deemed sufficiently important to have listened to that day himself. In a court battle for possession, such information might provide Jaworski with proof of relevancy, but Haig saw a possibility of bringing Watergate, at least the special prosecutor's investigation of it, to an end if Jaworski could be convinced that the White House had nothing to hide. He persuaded Nixon. And so on January 8th, Jaworski came to the White House and listened for half a day. The quality of the tape was not good. Much of it sounded like gibberish. Jaworski asked for a copy to take back to his office. Bizart said it was out of the question. The president and Haig were in San Clemente. Bizart called Haig, and the general told him to let Jaworski have the copy. Bizart replied that Haig must not realize what was on the tape. Haig said Bizart was being too cautious. He ordered Bizart to turn the copy over. The next day, Bizart received a letter from Jaworski requesting 25 more White House tapes. Bizart phoned Haig once again. Haig felt that he had been double-crossed. With trepidation, he informed the president. Nixon ridiculed Haig for his trust in Jaworski. Never again, said the president, would he give up any more tapes, not under any circumstances. Jaworski's deputy, Henry Ruth, always found Garment ready to listen to reasonable argument. In early February, they met for lunch, at Ruth's invitation, at a restaurant on the Potomac waterfront in southwest Washington. Could Garment possibly persuade the president to resign, Ruth asked. He was certain that Nixon was headed for impeachment and conviction. Resignation, he argued, would spare the country a terrible convulsion. Garment listened impassively, offering no hint that he had already tried and failed to make the same argument to Nixon. Ruth was virtually certain that the president would never resign since resignation would leave him vulnerable to prosecution. Still, Ruth wanted to try. Later, Garment briefed Haig on the conversation, and the general took notes. Haig shook his head. No, this wasn't the time to take such a message to the president. In the days that followed, Jaworski spent long hours in his small, dark office on K Street in downtown Washington, days and nights given over to thinking and debating with his key assistants. In the 48 years since he had made his courtroom debut, defending a man accused of moonshining in dry Prohibition-era Texas, Jaworski had never imagined he would have to face a decision such as the one he confronted now. With the tapes and Dean's testimony, there was sufficient evidence to indict the president for conspiracy to obstruct justice in the Watergate investigation. The unresolved question was pervasive, hanging over the prosecutor's office, a frightening possibility on the one hand, and on the other an incomparable opportunity to prove that no person, not even the president, was above the law. The handful of lawyers who were familiar with the evidence and who knew the decision Jaworski had to make debated the point heatedly in their cramped offices. Every legal, constitutional, moral, and practical ramification they could think of was hashed over. President indicted. That would be the screaming headline if Jaworski decided to go forward. Jaworski's instincts were against it. Perhaps he had already decided not to, and further talk was superfluous, his aides thought. But the debates continued, and Jaworski took them seriously. The legal complications of indicting a sitting president were almost argument enough not to. The Constitution said clearly that if a president were impeached and removed from office, he was subject to criminal prosecution. But it was silent on the question of whether an indictment could be brought while he remained in office. If the president were indicted, his lawyers would challenge the indictment. A legal and public relations offensive would be launched against the special prosecutor's office. The White House arguments would be strong. Ziegler and St. Clair would pound away at the ghastly spectacle of a president on trial in a courtroom. There seemed to be some reasonableness to the position they would probably take. What would the president do if someone started a nuclear war? Ask for a recess? Also, the question of indictment would doubtless go to the Supreme Court. This would delay the trial of the other defendants charged in the conspiracy. With impeachment proceedings underway, a good argument might be made that indictment represented a form of double jeopardy against the president. There was the awful thought of an arraignment. How would Jaworski get a sitting president into court if, as seemed likely, he refused to come voluntarily? Would the special prosecutor send the marshals to pick him up at the White House and drag him to court? A ridiculous notion, but if it got down to raw power, the president had the armed forces at his disposal. Jaworski calculated that the Supreme Court would have good reason, probably a duty, to rule the indictment unconstitutional. In addition, Jaworski was persuaded that he had an obligation to look beyond his prosecutorial role. Could a president or the presidency function while the chief executive was under indictment, on trial? What would the president's indictment do to the country's position abroad? The action would taint, if not demolish, every act of the chief executive. Jaworski firmly believed that. Even routine appointments and nominations would appear suspect. Jaworski was doubtful of his right to take such a monumental step, and he also pondered what the personal consequences would be. It could go down as one of the great blunders of history. He was not about to accept such a burden, and he questioned the wisdom of anyone who would choose to do so. That, Jaworski reflected, must be why impeachment and removal have been assigned by the Constitution to the elected representatives of the people, the House and the Senate. The presidency was too much for one prosecutor and a grand jury of 23 citizens to take on. Still, the debate in Jaworski's office continued full scale, tedious, often bitter. Some of the attorneys did not feel that the House Judiciary Committee could be relied on. The president's participation in the cover-up was a criminal matter, while impeachment was political. The committee could find many ways to evade its responsibility. Anything could happen. But Jaworski had faith in the committee and particularly in John Doerr, and the prosecutor was searching for some way to give the committee some help. Doerr was doing his best to prevent the inquiry from becoming politicized. When he discovered the Judiciary Committee members could attend interviews of witnesses who had been placed under oath, he switched to informal, unsworn interrogations for purposes of preliminary investigation. Some committee members, particularly Jack Brooks, a feisty Texas Democrat, were infuriated. Brooks started referring to Doerr as the chairman. On February 14th, John Doerr met with James St. Clair for the first time. St. Clair wanted to know how the committee was going to define an impeachable offense. He wanted it narrowed to a clear violation of criminal law, commission of a felony. The lawyers sparred. St. Clair asserted that it was necessary to define the alleged offense if he was to know how to respond. He made clear that he had no authority to consent to anything without the president's approval, especially if the committee did not agree to such a basic ground rule. Doerr didn't wish to concede anything. He knew he was in trouble. The Constitution granted the House of Representatives the sole power to impeach, but Doerr well knew that the president held most of the cards. The committee could ask for material from the White House, could even subpoena it, but the president could say no. Rodino and Doerr were both convinced that the committee must never go to court to get documents or tapes, as the special prosecutor had done. If they went outside the Congress, it would be a concession that the House's, quote, sole power to impeach was subject to interpretation by the judicial branch. Accordingly, Doerr and Rodino decided that they would have to rely on the willingness of the president to turn material over, or they would have to summon the power of public opinion to force his hand. Almost from the outset, Doerr had proceeded on the assumption that with such limitations, the committee was unlikely to find a single tape, a single other piece of evidence, the smoking pistol, which would connect the president conclusively to a clear criminal offense. Doerr's skills were those of a scholar rather than an investigator. He pored over the record with his aides, material from the Senate Watergate Committee, the grand jury testimony, and the White House statements. Doerr's staff did little primary investigating. As they sifted through the evidence, they would go hot and cold, convinced at one moment that they could make a case for impeachment, and at the next that the White House could stonewall them to the end. There was a pattern of flagrant abuse, wiretapping, concealment, half-truths, outright lies, consistent misuse of the executive power, but there was very little to tie specific criminal activities directly to the president. Though Doerr expounded the theory that a president was responsible for the actions of his subordinates, both he and Rodino knew that an effective impeachment case could not be made without direct evidence. Impeachment based merely on the strength of the witnesses was inconceivable. The case would then rest almost wholly on John Doerr's uncorroborated accusations. Doerr was in much the same position as Archibald Cox had been in the fall. He needed the tapes. Doerr and Minority Counsel Albert Jenner had several meetings with Jaworski. Doerr explained their dilemma. There was little to catch hold of beyond the broad pattern of presidential misconduct. He doubted that it would be sufficient to move the politically sensitive committee. He needed more evidence. Jaworski explained his position. He had the evidence, but he lacked the mandate to proceed. Dorr wanted the tapes. Jaworski wanted him to have them. But the special prosecutor's position was delicate. He was still negotiating with the White House for more tapes and more documents, even though Haig and St. Clair had indicated that his chances were slight. If he passed on to Dorr what he had now, it would wreck whatever chance he had to get additional evidence without a court battle. Jaworski was intent on quieting the debate that raged in his office. He admired the zeal of the assistants who were pressing for the president's indictment, but he also acknowledged to himself that the White House had a point. Some of the young lawyers were partisan. There were a few Kennedy Democrats who sometimes allowed their ideology to lead them, who would indeed be gleeful if a panel of 23 citizens dragged President Nixon into the dock. Jaworski saw his job as arbiter between extremes. He thought of himself as different from Cox. Cox was wedded to scholarship, to procedure, and Jaworski believed to a pristine vision of the law as a monument to man's goodness. Jaworski was more a realist. He was not a professor, but as a decision-maker. Practical. The man who talked both to Al Haig and to the young Kennedy Democrats on his staff, and to everybody in between. The task was to find a middle ground, not to indict Nixon, but certainly not to walk away from the evidence. He wanted to throw the ball to the House committee, but only in the shape of well-organized and complete evidence. He wanted to give Dorr a roadmap that included the tapes. Then it would be up to the Judiciary Committee. Jaworski outlined the principles that must govern such a transaction between the prosecutor and the committee. First, the evidence itself could not be made public by his office, but the White House should be told that a transaction was taking place so that the president would have an opportunity to raise objections. Second, the evidence would have to be transmitted from the prosecutor to the committee through the judicial process. Jaworski was not going to send his deputy down at midnight with a U-Haul truck. There would have to be an intermediary. Someone or some group had to receive the material and hold it while the White House had time and opportunity to seek a judicial remedy. Finally, the evidence could not be presented in an accusatory manner, nor could it be accompanied by any conclusions. It must be basic, raw, uninterpreted documents, testimony, and tapes. It would have to come to the committee from the grand jury, by the grand jury's vote, not from Jaworski. There it was. In the last week of February, Jaworski met with the grand jury. The panel had been investigating Watergate for 19 months. He knew from those of his assistants who usually met with the jury that the jurors were determined to indict the president. They had voted unanimously in a straw poll to charge the president with a crime. When the vote was taken, some of them had raised both hands. Solemnly, Jaworski outlined the enormous problems that were posed by indicting a president. Though he agreed that there was sufficient evidence to charge the president with a crime, there were other ways to proceed. In unusual circumstances, grand juries had sometimes issued reports. He suggested that a report be drawn up and given to Judge Sirica to be transmitted to the House committee. The members of the grand jury had many questions. Some of them were so incensed at Nixon that Jaworski was afraid he might have a runaway grand jury. With slow and reasoned argument, the special prosecutor told them that he understood their feelings and shared their frustrations. But he insisted that such a report represented their best way of holding Richard Nixon accountable. In the end, the jury agreed. It then voted in secrecy to indict Haldeman, Ehrlichman, Mitchell, Strawn, Colson, Robert C. Mardian, and Kenneth Wells Parkinson. And in a footnote, they explain, Mardian, formerly Assistant Attorney General in charge of the Justice Department's Internal Security Division, was one of Mitchell's assistants at the Committee for the Re-election of the President. Parkinson, a Washington attorney, defended the Re-election Committee in an invasion of privacy suit filed by the Democratic Party after the Watergate break-in. He was later acquitted. Following Jaworski's advice, the jury named Richard M. Nixon, President of the United States, as an unindicted co-conspirator in the plot to obstruct justice. That information, Jaworski had informed the panel, would go only to the judge for the time being. The vote was unanimous. Jaworski went to see Judge Sirica. You can expect a report from the grand jury, he said. The grand jury wants the report to be sent to the House Judiciary Committee. It pertains to the president. That brings us to the end of Chapter 9. Thank you for watching. Next time we will take up with Chapter 10.